A little bit here. Case 14-1788 at BASSAM or BASSAM, I apologize if I'm mispronouncing, Trading Company Limited versus Wheeled Coach Industries, Inc. Okay, counsel, whenever you're ready, sir.
Good morning. May it please the court. I'm Bill Rapolo, and I represent BASSAM Trading Company. In this appeal of a lower court's order enforcing a settlement agreement that was reached through mediation, and notwithstanding Rule 1.730 of the Florida Rule of Civil Procedure, the agreement was unsigned by both the parties and their counsel. In Florida, unlike many other states, the legislature and also the legislature has passed rules that govern mediation. And the Supreme Court has promulgated rules which lay out for the litigants and their attorneys, when you're in mediation, exactly what the rules are, when they start, when they stop. In our case, the rules state that, Rule 1.710 states that mediation, it can go on, it should be completed within 45 days of the initial meeting. That rule tells litigants that, okay, well, it doesn't just, after your first day of mediation, you can continue on, and it may go on for 30 days. The rule also says that if the parties agree, it can go on past 45 days. Then there's Rule 1.730, which discusses when mediation ends. And 1.730A says if there's no agreement, what happens? If there's no agreement, then the mediator shall file a report with the court informing that there's no agreement. Or if there is an agreement or a partial agreement, then the parties must reduce it to writing. Both the parties and their counsel must sign the agreement, and the mediator can either inform the court of the partial agreement, or the parties can file it with the court.
What facts in this case support that this was in fact a mediation settlement agreement as opposed to outside of mediation? For example, did the mediator file a report indicating the outcome?
Precisely, no. What happened is, on October 31st, 2013, the parties had a physical mediation at mediator Jay Cohen's office. They have the mediation. The mediator gives them, they discuss settlement. The mediator says, here's what, there's 5 terms that seem to be a potential area where we can settle. Come back in 2 weeks to me, or tell me in 2 weeks if we can agree to it. 2 weeks later, both the parties informed the mediator that those 5 terms are agreeable. We've made progress. Now what's the next step? Let's try to get that in writing. Let's reduce to writing, pursuant to the rules. The mediator is still involved. What happens then? The appellee takes the first crack at a draft of the settlement agreement from the mediation of what they've all discussed in mediation, puts it out there, importantly puts in there that the agreement should be signed by both the parties and their attorneys, which is pursuant to Rule 1.730. And then at that point, some drafts go back and forth. But the parties never signed the agreement. There are some issues back and forth.
If negotiations start through mediation, and they can't come to an agreement, and then the parties either adjourn or leave, and they continue to negotiate, and they continue amongst themselves to hammer out an agreement. When does the mediation stop, and when does the settlement agreement amongst themselves commence, so that you don't have to have this writing requirement?
Well, Your Honor, the rules say that it stops when the mediator files a report with the court saying there's an impasse. That's what the rules say, and that's what the litigant should be able to follow the rules and understand what the rules say. In addition to that, we have some cases that have held that even after mediation, even if a mediator says that there's an impasse, and subsequently the parties come to an agreement from that mediation, the mediation rules apply. And I refer to the Dean case out of the fourth DCA from 2009. That's exactly what happened in the Dean case. But throughout the state of Florida, courts have held that if there's an agreement that comes from mediation, it's got to be signed.
So if they're at mediation, they adjourn, they continue to talk outside of the actual physical mediation, and they reach an agreement, but it's different than the tentative structure of the agreement coming out of mediation, then that different agreement, different terms, that could be orally agreed to, and then we're outside of 1.730?
Your Honor, I think the mediator here controls. I mean, if we look at the rules, I mean, if the mediator stays active, in our case, the mediator stayed active. The mediator was in touch with the parties through December. The mediator held a conference call with my client on December 18th. If the mediator is still active and they come to an agreement that is in addition to what the mediator says, and the mediator has not filed a report with the court, the mediation, those rules still apply because it's still with the facilitation of the mediator. That's why the mediator is still involved. And that's what the rules say. If the mediator...
But the signature aside, why isn't there an agreement here? The trial court apparently thought that there was.
Well, the main issue, Your Honor, is that there's nothing signed. There's no agreement. I understand.
Let's set that aside for just a minute.
If we go to the reason why...
There's no mediation, and they reached an agreement without a signature.
What is in writing and what was passed back and forth through the parties, there were some terms in there that no one agreed to. I think one of the key issues
Well, it was the deregistration with the Saudi ministry, right? Wasn't that the main thing that you're claiming wasn't agreed to, and that was a material part of the agreement, and then without that you couldn't have an agreement, right? Is that it?
That's one of two. Well, what's come up recently with this appeal is that...
But didn't your attorney, or one of your attorneys testify that really wasn't an important issue or material issue, and that, you had an agreement without that?
Well, Your Honor, and that's why these rules are so important. And what they do is they keep the confidentiality. And here what happened is there was an evidentiary hearing where you have an attorney with a financial interest in the case who suddenly turns against his client and comes up with his opinion. His opinion differs.
The judge could weigh that and decide whether that was credible testimony or not, keeping, understanding that the attorney had a, quote, vested interest in making sure in hoping that there was a settlement so he would get paid. But that's a factor that the judge would analyze and saying, okay, I think there is an agreement, or no, there really isn't, because I discredit that lawyer's testimony. That's the judge's prerogative.
Well, there is the issue of the deregistration, which my client contends is different, because...
testimony that was just a minor thing, and it wasn't difficult to do, and that really wasn't even even your own lawyer testified that wasn't even a material part of the agreement.
Well, my client's former lawyer testified that.
Yeah, right.
But if we just look back at what that issue says, my client's former lawyer said it was nothing, it was easy to do. But what that term in the agreement, why it's so important is because the appellees, they get the benefit immediately. It's from As it looks now, November 14, 2013, the agreement is effective, they're done. My client doesn't. My client has to wait what could be an indefinite period, which it could be a week, could be 2 weeks, could be a few months, we don't know, it could be a year before they get the benefit back. And that was a point that was very important, and it was a point which...
In essence, the terms were, WCI pays your client $2 million, suits dismissed with prejudice, mutual general releases, acknowledgement of mutual termination of the distribution agreement, and then BTC had to deregister the distribution agreement with the Saudi ministry. Those were the agreed upon terms. What I thought became the sticking point was the mechanism of how the deregistration would occur, and that lawyer, your client's former lawyer, testified that that really wasn't a material issue in the actual terms of the settlement agreement. Wasn't that? And the deregistration problem became a little more problematic, the path to doing that than first hoped for, but that really was, I think they were talking about, that wasn't an essential term of the agreement. Is that right?
My client's former counsel testified in his opinion it wasn't an essential term.
Right.
The reason that my client, and if you look at, even though my client's former counsel testified that, in the record, we have an email with him telling the opposing counsel on December 23rd, 2013, that that term is a deal breaker. Now, 4 months later, you're right, he comes out, testifies against his former client and says that it really wasn't an essential term, although he did put in an email, December 23rd, 2013, that this was a deal breaker. And again, it goes back to...
If there's evidence in the record that indicates that wasn't even a material issue and that there was an agreement without that, I mean, and the trial judge made that decision and made that finding, how are we supposed to reverse that?
Well, everything goes back to mediation. We can't...
I'm talking about absent your signature argument now. I mean, that's something, that's a technical, either if it was mediated and it was a mediated agreement and it wasn't signed, that's one thing. But I'm just saying, set that aside for just a minute.
And I will set that aside, but quickly...
That there was an agreement without the deregulation from the Saudi ministry, and that the agreement had already been reached, according to your former attorney. And there's evidence, the trial judge made the finding that there was an agreement, so how are we supposed to reverse that, absent the technical requirement of the signature?
Well, what also came up, which we raised in our motions, was there is an issue regarding the effective date and the release. And that...
You're talking about the effective date of the release and the effective date of the agreement?
That's correct, Your Honor.
Be remanded back so that the dates coincide, right?
Well, no, Your Honor, because the appellees filed the cross appeal. And what their cross appeal said, well, the effective date was wrong. We actually negotiated it should be 11 months forward. And what that tells us is that the appellees, they don't even know what the effective date was because it was not agreed upon. The release date wasn't agreed upon. It was something that was back and forth. We look, there's emails on December 9th and December 13th that are exhibits to the initial motion to enforce the mediated settlement agreement. And in those, it's contemplated, well, what are the effective dates? And I point your attention to a recent case, which we've cited, which is the Johnny Thompson case out of the 4th DCA from November 2014. In that case...
Well, let's just assume for purposes of argument that there was an agreement. What do you say the effective date was? If we just assume there was an agreement, what would the effective date of the agreement be?
First, Your Honor, I can't assume that there was an agreement because we never had an agreement.
Okay, so they say, I think the opposing counsel will say November 14th, 2013. Would that be a correct date or not?
Well, in the cross appeal, they didn't say that. In the cross appeal, they said it was actually October 2014. They thought it was negotiated 11 months in the future, under a release, which wasn't. And that's why it's so important, because the Johnny Thompson case says that if the parties can't agree on the release indemnification, that's it. There's no meeting of the minds. That's a material term in itself. It finds the agreement is unenforceable. And that's what we have here. And Judge, you've brought up the technicality. There's been cases throughout, up and down the state, who said that these rules are not mere technicalities. We go back as far as 1997, the Gordon case, the third DCA, they went to the extraordinary remedy of issuing a writ, preventing an evidentiary hearing. And then we've got the Masstec case from the third DCA in 2008, which specifically said that the third DCA holds that the signature of the parties is more than a mere technicality. Even this court, back in 1995, with the Jordan case, that court held the importance of the signatures. The reason why they talked about the technicalities is because you had a factual scenario where the parties themselves not only signed the agreement, but they actually ratified the agreement because they acted upon it. They acted under the agreement. That's very different. These rules are not technicalities. We've cited in our briefs abundance of case law where courts have continually upheld these rules.
You're into rebuttal time unless you can keep going if you want. Just.
If there's not any more questions right now from the panel, I will hold my time for rebuttal.
Thank you, Counsel.
Thank you.
May it please the court, my name is David Jones of Holland Knight. I represent the Applee and Cross Appellant Wheeled Coach Industries, Inc. With the court's permission, I'd like to spend a minute on the standard of review because there's a difference of opinion on what the standard of review is before this court. I then, again, if the court is of like mind, would like to spend just a minute or two on the issue on cross appeal because I think that's discrete and can be dealt with fairly quickly, and then use the remainder of my time to address appellant's arguments on the main appeal and any questions the court may have. That's acceptable.
Go ahead.
With respect to the standard review, and I'll just use the BTC as an acronym for the appellant, BTC claims that the trial court's interpretation of a settlement agreement, including one reached pursuant to mediation, is reviewed on a de novo basis. The argues that they raise on appeal, however, do not involve interpretation of either the language.
We have a factual issue as to whether the parties came to an agreement or not?
We do indeed, Your Honor, which is why we suggest that the proper standard of review is whether or not there was competent, substantial evidence.
Let's move on. Listen, you wanted to talk about the date. So you say the date is November 14th? What do you say the effective date of the agreement is?
It would be the date in November. I believe it was the 13th or the 14th upon which...
Why do you say that?
Because that is the date upon which both parties communicated via email to the mediator acceptance of the 5 mediator proposed terms, for lack of a better phrase, that formed the basis of the agreement.
Why isn't this a mediated settlement agreement that requires a signature?
Because the agreement that as it involved issues that went well beyond those 5 issues. Significantly, and many of the cases discuss this, there are cases that have been cited by both sides in which one of the reasons there was a determination that there was not a settlement agreement is because there was never agreement, for example, or a meeting of the minds with respect to release provisions, the scope of the release, the parties to be released. That was one of the subjects of extensive negotiation, and Exhibit A to the trial court's final order, which the undisputed testimony embodied the agreement of the parties as to all terms of the settlement other than the timing of this deregistration versus payment issue. Not only...
Then, in terms of because the trial court entered 2 different orders, correct?
That's correct.
The first order, and then followed by a second order. And I believe that was prompted in part by Wheeled Coach's motion to add specific provisions. I think there were 6 actually that were requested and 5 that ended up in that second order. So if that's the case, then if there are additional requests made to be included within that agreement, how is this not essential terms that have now been added to the order?
The terms that were added, in other words, the separate items that the trial court said, I'm saying this is the agreement of the parties, Exhibit A, with the following exceptions. Those were not things that we asked for. That was not the reason we went back to the trial court. We went back to the trial court because we said the first order wasn't a final order. All it said is, I approve the settlement agreement and find that it's enforceable. Okay, what does that mean? When do they need to perform? When do we need to perform? And we didn't feel that that had sufficiently, in other words, if there's an order that merely says motion granted, without going into detail, it was not a final order under the appellate rules, and in fact, we filed a motion to this court to relinquish jurisdiction, raising that argument, and the court did relinquish jurisdiction for that purpose. We didn't seek it to add additional terms to the agreement. The only reason those additional terms, for lack of a better term, or exceptions to the parties' agreement were inserted by the trial court is because of the lapse of time and the circumstances of the case. The exceptions to the written agreement attached as Exhibit A to the final order were as follows: that the document need not be executed by the parties or counsel, the court having already ruled that the agreement was enforceable. So that wasn't a change to the agreement. It was just recognition of the fact that the guy refused to do it once. He's in Saudi Arabia. I'm not going to require signatures now as a technicality because I've already found that Rule 1.730 doesn't apply to this agreement. Secondly, providing for an effective date of the order. The effective date in the agreement negotiated by the parties and the undisputed evidence showing embodied the entire agreement with the sole bone of contention remaining the issue of timing of the payment versus timing of Mr. BASSAM deregistering the agreement with the Saudi court. The court said the overall agreement will be effective as of the date of the order, except for the release provisions, which will be effective as of November 14, because of opposing counsel's argument below that we didn't bargain we didn't bargain to give them an extra, whatever it is, 9 or 10 months of release. Well, the only reason that there was that discrepancy is because of their failure to abide by the agreement. As we say in the cross appeal, the appropriate thing for the trial court to have done would have been to have made all provisions of the agreement.
You're just saying that the release in the agreement should have the same date, which would be November 14th.
That's correct, Your Honor. Because, and in fact, there was a suggestion that we suggested November 14th as the effective date of the release, or that the parties negotiated for some future effective date of release, or that was a bone of contention. That's not the case. The release date plugged in by the trial court was the date that the final order was entered. Those were the two dates. One was the date upon which the parties communicated acceptance to the mediator. The second effective date was the date of the final order. The agreement attached as Exhibit A, which again, the undisputed testimony was that it embodied the entire agreement of the parties with the exception of this timing of deregistration versus payment, provided for a single effective date. And the reason for that is plain. The trial court, we suggest inadvertently created a gap during which the release became effective in November of 2013. And as the court knows, a release can only apply to past acts. You can't release somebody for potential future acts. But the effective date of the other provisions, including the provision wherein both parties acknowledge that the exclusive distribution agreement was terminated, was some 9-10 months later, the date of the final order, which puts my client in the untenable position of having a release that cuts off as of November 14, as of November of 2013, and yet the contract that really was what the settlement was all about could have been argued by Mr. BASSAM to have remained in place for another 10 months. That's clearly contrary to the overall scope of the agreement. We suggest it was invited error by Mr. Rapolo at the hearing which preceded entry of the final order, and I raised that issue that there needed to be a single effective date as opposed to two effective dates. And unless the court has further questions, I think I've addressed the issue on cross appeal. I need to point out a couple of statements made by Mr. Rapolo. I would hope inadvertently, with regard to some of the facts. They, both in their brief and in oral argument, suggest that the mediator, Jay Cohen, was intimately involved with the negotiation and evolution of this agreement between November 14th of 2013, the date on which both parties communicated to the mediator their acceptance of the 5 basic mediator-suggested terms, and December, mid-December, late December, when the wheels fell off because of this timing issue of deregistration versus payment. That just quite simply isn't supported by the record. First of all, BTC argues at page 9 of its initial brief that Exhibit A to the final order, which the undisputed testimony showed embodied terms that were all agreed to except for this timing issue on deregistration, is a document, and I quote, that mediator Cohen had circulated, and they cite supplemental record at 41, that just isn't true. That document was prepared by me, was sent to then opposing counsel, was never sent to the mediator. They talk about this conference call that supposedly took place with their client on December 18th. Well, they asked BTC's former counsel about that, and he said, I think my associate sent a couple of emails to Mr. Cohen, and there may or may not have been a phone conversation, but if there was, I wasn't involved in it. So there's no testimony that this single phone conversation ever took place on December 18th between some conglomeration of people on their side and the mediator. There's just no evidence of that. And there's also no evidence of the record, and I will represent to the court that just didn't happen. There's no evidence that the mediator had any involvement whatsoever in this process from the day that we left my conference room. It wasn't conducted at Mr. Cohen's office on Halloween, October 31st of 2013.
And what's the purpose of telling the mediator that you've reached an agreement on these five parts of the agreement?
Because that's what the mediator told us to do. He said, I don't know if you all are familiar with Mr. Cohen, but he's known as a pretty aggressive and sometimes unorthodox mediator, and he likes to get the job done. And he said, it looks like this case is going to impasse. I'm going to try a flyer. Here's 5 terms. See if you guys can agree to them. If so, send me an email. If either side says no, then I'm going to file a report stating that there's an impasse.
What was he supposed to do after you sent him the email saying that you had agreed to the 5 terms? What was he supposed to do?
I don't know what he was supposed to do.
Did he do anything at all?
Beg your pardon?
Did he do anything at all?
He did not, other than send a bill to both sides for his mediation fees.
He did not file a report with the circuit court.
He did not file a report with the circuit court. And furthermore, the testimony of former counsel, and we cite this in our brief, and indeed a representation made by BASSAM's current counsel, is that the mediation was unsuccessful. The undisputed testimony in this record by former counsel and an admission made by Mr. Rapolo at the hearing held on the final order is that the mediation was unsuccessful. The undisputed evidence is that there were extensive negotiations over the course of the next October through mid-December month and a half, 6+ weeks, at which all terms had been negotiated and agreed to with the exception of this timing issue. Now, there's a suggestion made by the other side that the reason this was a deal breaker for BASSAM is that he didn't want to wait for his money and be subject to the whims of the Saudi government as opposed to how long they would take to take care of this deregistration, and indeed whether they would even accept the deregistration. There's no evidence whatsoever in the record supporting that argument. The undisputed evidence in the record, and prominently that of BASSAM's Saudi law expert, is that the process is simple. Mr. BASSAM walk into the registry, hand them a piece of paper that says that exclusive distributor agreement I have with Wheeled Coach, we don't have it anymore. Please deregister this. The Saudi government is not quite as e-savvy, apparently, as this court, and rather than having some sort of computerized file, somebody literally takes a pen and marks an X through the page in their books where this distribution agreement is registered. All of the testimony is that that is a ministerial, non-discretionary act of the Saudi government, and all of their arguments to the contrary not only come very, very late in the game, but are just not supported by anything whatsoever in this record. The issue didn't involve what the mechanics of deregistration were. That's not a point that the parties could negotiate. They were what they were. They're whatever the mechanics are for deregistration under Saudi law. And both Saudi law experts and their reports or excerpts of their reports are in the record is that BASSAM files a piece of paper that says, I want you to deregister this, and they draw a line through it, and it's deregistered. The issue arose because BASSAM wanted to get paid first. Understand that here, the plaintiff in this case is a Saudi national with no presence in this country. If my client wires $2 million to an account in Saudi Arabia, and then Mr. BASSAM says, nanny, nanny, boo-boo, and doesn't deregister it, what is our remedy? Frankly, neither this court nor the trial court has a whole lot of leverage to compel him to do this. He could just dismiss his lawsuit, he could prosecute here, he could bring additional proceedings against us in Saudi Arabia, and we'd be out $2 million, and there'd be nothing that we could do about it. And there are plenty of cases that say the issue of, with respect to non-essential terms of an agreement, and there is case law that says the timing of the payment by one party versus the performance of an act by another party, it's a detail. It's not a material term. In fact, the process that was ultimately embodied in Exhibit A to the final order was one that the record reflects was suggested by BASSAM's counsel. BASSAM will file the notice of deregistration with the Saudis, provide me with a copy of it. 3 days later, my client will put $2 million into my trust account, and as soon as we verify that the deregistration has taken place, he'll get his money. With respect to well, let me mention a couple other things. And there's been a representation made here today that there was no agreement. Again, that is completely contradictory to the record. Their briefs all reflect that they do not deny that every single term in that piece of paper attached as Exhibit A to the trial court's final order was agreed upon, except for this issue of when does my client pay the money versus when does Mr. BASSAM file the deregistration paper. The argument that there was no agreement is not supported by this record. But let's go further than that. Let's look at what BTC did during the 6 weeks following the mediation while these extensive negotiations were taking place and drafts were being exchanged. One, was there any further prosecution of the case in this court? No. Depositions were canceled. Documentary discovery that was in process was halted. And interestingly enough, and significantly, I suggest, Mr. BASSAM, the president of BTC, the plaintiff, had a telephone conversation with another ambulance distributor other than my client over business completely unrelated to this case. And during the course of that telephone conversation, which took place on November 27th of 2013, about a month after the mediation and about 2 weeks after both parties communicated their acceptance to Mr. Cohen of the 5 core settlement terms, and he said, by the way, I had a big lawsuit against Will Coach, and I just settled it for, and the witness couldn't quite recall whether Mr. BASSAM said millions of dollars or $2 million. In point of fact, the settlement amount was $2 million. Incidentally, that was supposed to be confidential, but that cat was let out of the bag by Mr. BASSAM during the phone call, and when it came out during Mr. DeForge's deposition, once the horse is out of the barn, the horse is out of the barn, so there's no point in shying away from it. So here you have behavior of the party that is consistent with an agreement having been entered into. And that distinguishes this case from any case that the plaintiff/appellant relies upon. Now, let's assume for a moment that their position was, as I submit it isn't, despite argument made here today, they never contend in their briefs that there wasn't an agreement. They contend there was a sticking point over this timing issue on the deregistration. Well, they certainly could have called Mr. BASSAM to come in and testify as to the lack of an agreement, but they didn't. They could have had Mr. BASSAM, there's been some impugning of the character and the motives of Mr. BASSAM's former counsel. They could have come in and talked about their former lawyer acting beyond the scope of his authority, and they didn't. The undisputed evidence in this record is that every point of the deal was agreed to except for what happens first. It's a chicken and the egg question. Does my client write the check, or does Mr. BASSAM file the notice of deregistration? The trial court correctly, based on evidence or based on case law, which talks about the existence of a remaining dispute over a non-essential term of an agreement, such as timing of payment versus performance of an act, is not sufficient to cause an otherwise agreed to contract, in this instance a settlement agreement, to be enforced.
One final question. The orders, I have to go back and take a look regarding the effective date. You're claiming that it was November 14th, and the order, I'm trying to remember the date that the order was, just refresh my memory.
I will be happy to, Your Honor. The final order provided that the effective date of the overall agreement would be the date of that order, which was October 21st, 2014, but that the release provisions set out in sections 3 and 4 of the agreement attached as Exhibit A to the final order would be November 14th, 2013, some 11 months prior. It is our position that the correct thing for the trial court to have done to avoid this gap issue would have been to have made it the effective...
I just couldn't remember the date that was included in the order as to the effective date, which would have been the same date of the order. Okay.
And the relief that we request, the relief that we request on the cross appeal is for the trial court to make the effective date of the entire agreement, including the release provisions, be November 14th, 2013.
But you've already got the release provision as November 14th. So if you just if the effective date of the agreement is November 14th, then the dates coincide.
The effective date of the rest of the agreement should be that same date, not the date of the order.
Right.
Okay, counsel, your time's expired. Okay, thank you.
Thank you, Your Honors.
$427?
First off, on page 793 of the record, during my cross-examination of my client's former counsel, on 791 and 792, I was asking him about the mediator's continued role. He was a little hesitant, and finally on 793, line 2, I said, was there a phone call with the mediator? And he acknowledged, yes, there was. So we've got the mediator being involved in this case through December 18th, which is 1 week before I got involved. These rules are there, and they explain what happens during mediation. Litigants should be able to rely on these rules. We have here a mediator involved in the case through December, talking to my client, explaining their agreement. Now, I also want to point out what the lower court, what the ruling was. In the first order, the judge found the agreement entered by the parties on November 14, 2013 is enforceable and shall be enforced by the court. That was the terms that the mediator laid out. That day was when counsel for both parties sent an email to the mediator telling him, Your proposal looks good. We agree to that. But, so everything that has been done is goes back to the mediation. If we look why we're even here today is because the appellees filed a motion to enforce a mediated settlement agreement. Their initial motion, everything in here discusses the mediation. The opening of their initial motion, defendant counterplaintiff Wheel Coach Industries Incorporated moves for entry of an order enforcing the mediated settlement agreement. The top of the second page. The parties mediated this matter on October 31st, 2013, and mutually accepted the mediated settlement proposal, parentheses, J. Cohen mediator, on November 14, 2013. However, as of this date, BTC has refused to execute a written document memorializing the terms of the mediator's proposal. Your Honors, I submit to you, this is exactly what these rules are for. Their motion to enforce their mediated settlement agreement falls well within Rule 1.730, and it has been enforced. That rule has been upheld by courts up and down the state of Florida. Finally, part of their initial motion, also in their conclusion, they state that, again, reiterate, the mediator's proposal is a binding settlement agreement. As a result, the court should enforce a settlement agreement. There's one problem with that. The rule requires signatures by not only the parties, but also the council. Now, yes, there has been some courts who have found that if the parties agree to sign the agreement, that can also be construed as enforceable. But in this case, we don't have anything. The parties didn't sign it. No one signed this agreement. Every part of this agreement, this negotiation stems from the mediation. Every part of the motion, as Mr. Jones just stood up here and explained to you the back and forth with Mr. Cohen, how he's an aggressive mediator. Well, what they're trying to enforce is exactly what the mediator J. Cohen put forward. And Your Honors, it's not a technicality. The Rule 1.730 is there. The Supreme Court promulgated it. Courts have upheld it, and parties should be able to rely on the rules that we have, that the Supreme Court states have. It facilitates mediation. When parties understand what they're getting into and what the ground rules are, that facilitates mediation. And that's one of the reasons why Florida, unlike many other states, has these rules in place. Thank you very much for your time.
Thank you very much, counsel. Okay, we'll stand adjourned.